Viewers, the simmering tension between judiciary and executive has erupted into a full-blown political war, with the BJP and Congress-led opposition trading barbs over allegations of judicial overreach. At the heart of this storm lies BJP MP Nishikant Dubey's remarks, accusing the Supreme Court of encroaching on legislative and executive domains, particularly in the context of the Waqf reform. Viewers, while the BJP president, Mr. Nadda, has swiftly distanced the party from Dubey's comments, labeling them personal opinions, the Congress has used this opportunity, branding the remarks an assault on judiciary's independence. The opposition claims that Dubey's outburst reflects the Modi government's frustration over setbacks in the Waqf case. The BJP has countered by invoking Congress's historical record of subverting judicial autonomy for political ends. Viewers, the opposition has framed Dubey's remarks as a desperate reaction to judicial pushback on Waqf. Congress calls it a matter of great sadness that an MP would question judiciary's authority, emphasizing that the Supreme Court's word is final in India's legal system. The BJP has countered by listing Congress's record. Viewers, while Nadda has distanced BJP from Dubey's remarks, other BJP leaders have doubled down on the narrative of judicial overreach and Congress's hypocrisy. The BJP has turned the tables or sought to turn the tables on Congress by highlighting its historical assaults on judicial independence. From the emergency era, suppression of supersession of judges, you would remember, to the introduction of the 39th Amendment during emergency to shield certain laws from judicial review. That Congress's track record is far from being spotless. The BJP has said that the Congress's sanctimonious defense of the judiciary is a convenient ploy to deflect from its own legacy of undermining institutional checks for political gain. Viewers, the judiciary versus executive debate is not new to our country. The Supreme Court's role as a constitutional guardian is indispensable, yet the judiciary must tread carefully to avoid perceptions of overstepping its mandate that can fuel narratives of unelected overreach that undermine democratic legitimacy. Viewers, there are many questions. Is this a case of judicial overreach or political overreaction? Or is it a collision of legitimate concerns and calculated outrage? The Supreme Court's scrutiny of the Waqf Act is a necessary exercise of its constitutional duty. But at the same time, the concerns about judicial activism merit a debate. But viewers, the Congress with its historical baggage must first introspect before grandstanding on this, on protecting the judiciary.
राष्ट्रपति को 3 महीने के अंदर फैसला करना, ये किस कानून में लिखा हुआ? इसका मतलब ये है कि आप इस देश को एनार्की की तरफ ले जाना चाहते हैं। इस देश में धार्मिक युद्ध भड़काने के लिए केवल और केवल सुप्रीम कोर्ट जिम्मेवार है। सुप्रीम कोर्ट अपनी सीमा से बाहर जा रहा है।
नहीं, जो गाइडलाइन पार्टी की आ गई है, हम उसके साथ हैं। और कभी-कभी सत्य सही हो तो भी बोलना नहीं चाहिए, क्योंकि हर चीज की एक मर्यादा होती है।
राष्ट्रपति सर्वोच्च है, राष्ट्रपति को कोई चुनौती नहीं दे सकता।
मणिपुर की बात थी, सुप्रीम कोर्ट ने, आपको याद होगा, सुओमोटो उसका कॉग्निजेंस लिया। पूरा वेस्ट बंगाल लगभग जल रहा है आज की तारीख में, और सुप्रीम कोर्ट की आंखें बंद हैं।
ये कांग्रेस पार्टी को देश को जवाब देना चाहिए कि ऐतिहासिक रूप से इसने हमेशा से हमारे सुप्रीम कोर्ट के जजेस और जुडिशरी का अपमान किया है। ये वही पार्टी है जिसने इमरजेंसी लागू करी थी। ये वही पार्टी है जिसके नेता ने, जब 2019 में एक जज ने राहुल गांधी के क्रिमिनल डिफेमेशन केस पर सुनवाई करके ऑर्डर दिया था, तो ये तक कह दिया था, वी विल चॉप ऑफ योर टंग। कांग्रेस पार्टी प्लायंट जुडिशरी में विश्वास रखती है, ना कि इंडिपेंडेंट जुडिशरी में।
Tushar Gupta joins the debate. Professor Monojit Mandal also with us. Tushar, what do you make of this showdown, the judiciary versus executive face-off?
Good evening, Pranesh. Look, it's not the BJP versus the judiciary. It's not the executive versus the judiciary. The BJP in the center and several states represents the will of the people. And we as common citizens are going to ask that what is the actual utility of Article 142? Please understand, I'll give you an example, Pranesh. In the Waqf hearing, the court was very worried as to how mosques, which are 300-year-old, will produce a paper deed or a paperwork if they have claimed a certain property under Waqf. But the other part of the transaction, where the Waqf goes on an acquiring spree without the paperwork, that wasn't questioned. So the people who study law, the people who are questioning Waqf, they'll obviously have their doubts that why Supreme Court only looking at one side of the transaction. I'll give you another example. Today, the court has come down heavily against Samay Raina, but it has given a free run, rather not the Supreme Court, but the high courts in several states to Kunal Kamra. So the law is different for one comedian, the law is different for another comedian. Look, at the end of the day, the hope of the people rests in the judiciary. Every time there is a conflict, one goes to the judiciary, even to the sessions court or district court, whatever.
Right.
But at this time, what people are looking for is clarity. If a court is intervening on a certain issue, what is the final stance? The court came in and stayed the farm laws back in 2020, 2021. What happened to Punjab after that? Did the protest stop? Absolutely not. They stopped after in 2025. Did the Punjab farmers prosper? Absolutely not. So where is the accountability of that institution that has the power to stay a law that has been formulated by the legislature? These are some legitimate questions to ask. This doesn't mean that everyone is up in arms against the judiciary.
Okay.
These are just some important questions for the sake of national interest that we must ask.
Professor Mandal, how do you see this? Because, as we are all aware, the kind of commentary in Bengal, especially from the ruling TMC, about, judicial orders, it's all in public domain.
The point is very simple, Pranesh. When it comes to causing maximum good for maximum number of people, judiciary must take responsibly. Like I have criticized the Supreme Court verdict on the teachers' recruitment. What 20,000 innocent teachers, which according to the Supreme Court were not guilty, their jobs were chopped off. They are like the question of maximum good for maximum people. But in this case, I think Mr. Dubey crossed the line way beyond, because the Supreme Court was talking again about the democratic polity of the nation. That when a legislation is lying, unsigned for years and years, the Supreme Court had to step in. Again comes to the question of maximum goods for maximum number of people.
Okay.
That is the fundamental principle of democracy.
Kamruzaman Chaudhary ji, has the Congress has forgotten its track record, sir? I don't want to, I have the list, but I'm sure you remember the instances.
Yeah, we have lost elections after that. The people have rejected us on the basis of those issues.
No,
so
but in the first debate, you were saying you lost the elections because EC was compromised and EVM was faulty.
So can I say my point, Pranesh? Basically, the degree Dubey's comment has been made some 2-3 days ago, I suppose. And till date, there has been no contempt against this MP, member of the parliament. There is not even a single case being filed, or the Attorney General has not yet given permission to prosecute this MP. Why is that so? The Supreme Court is criticizing the Supreme Court's judgment or the judges are death knell for democracy. You have got a favorable judgment when within 2 hours you get a judgment of the Sambal survey. Within 2 hours, that judge is God for you.
Now, Kamruzaman ji, sir, before I bring in Dr. Ranganathan and IP Singh ji, एक छोटा सा सवाल है सर, ये बताइए, do you remember when Prime Minister Modi visited the then CJI's residence for Ganesh Aarti? And do you remember what was said about Justice Chandrachud then by opposition members, sir? Then you forgot that you can't question the judges, you can't malign their reputation. You forgot all of this, Dr. Ranganathan.
Look, there was absolutely nothing wrong in what Dr. Nishikant Dubey said, because facts are facts. Facts do not go by opinions. They don't care about your opinions. Let me give you 9 clear-cut instances where the Supreme Court, in overlooking as well as overseeing blatant discrimination against Hindus not only, Pranesh, seeded resentment, it stoked the possibility of religious wars in this country, like what Dr. Dubey said. Number one, Kashmiri Hindus. Supreme Court turned the other way when it came to opening the cases of criminality in 1990 against Kashmiri Hindus, saying, quote, too much time had elapsed. This after the same Supreme Court constituted an SIT to look into the case of criminality in 1984 against the Sikhs that happened 6 years before the Kashmiri Hindu genocide. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 2. Waqf Act. For 30 years, the Supreme Court never found illegal an act that gave Muslims the power to claim any property as their own, that allowed them to annex any land housing a functional mosque, allowing Muslims to annex 20 lakh acres in the last 10 years. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 3. State control of temples. How can the state be secular and at the same time control only Hindu temples? Crucially, why doesn't the Supreme Court have the guts to, in the interest of equivalence, ask the state to control mosques as it does temples? If this is not seeding resentment among the Hindus and stoking religious wars, what is? 4. RTE. The Supreme Court has not only allowed but also ratified the conjunction of the Right to Education Act with the 93rd Amendment that forces only Hindu-run schools to give 25% reservation to the EWS. Muslim-run or Christian-run schools are not under such obligation. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 5. Free speech. Why did Supreme Court so ruthlessly come down on Nupur Sharma for merely quoting Islamic scriptures but let loose Udaynidhi Stalin? You rush in to call any speech against Islam as hate speech, but call hate speech against Hinduism as any speech? If this is not seeding resentment among the Hindus and stoking religious wars, what is? 6. Hindu ritualistic practices. Milords have banned animal sacrifice for Hindus but not halal for Muslims, even though both are religious rituals. Banning crackers during Diwali but allowing millions of tons of stubble to be burned during same month. If this is not seeding resentment among the Hindus and stoking religious wars, what is? 7. Places of Worship Act. In 2019, the Supreme Court willfully ratified the Places of Worship Act 1991 that obligates maintaining all religious places as they were on August 15, 1947. Thousands of historical injustices can now never be addressed. A legal recourse, Pranesh, to correct historical injustice cannot be denied to democracy. If this is not seeding resentment among the proceed this thing, what is it? 7. 8. Shabrimala judgment. The simple question to be asked was it discrimination or perceived discrimination? There are many Hindu temples where men are barred entry. A Supreme Court that correctly removes discrimination from the Hindu religion but cowers behind a lamppost like a wet cat when it comes to other religions is not a Supreme Court. It is a Sharia court. If this is not seeding resentment among the Hindus and stoking religious wars, what is? And finally, 10 seconds, CA protests. The court, Shaheen Bagh and anti-CA protests were all intertwined. It resulted in terrible 2020 Delhi riots. About the blockade, the illegality of it was not addressed. But the Supreme Court, despite recognizing illegality, went for mediation. Would the Supreme Court ask for mediation for everything that it says is illegal? If this is not seeding resentment among the Hindus...
I just give you the last 10 seconds, sir. Mr. IP Singh, when people ask who will judge the judges, तो इस सवाल का क्या जवाब देंगे?
बस यही जवाब है कि निशिकांत को अगर सही साबित करना चाहती है बीजेपी और ये पैनल में आप सही साबित करना चाहते हैं तो न्यायपालिका में ताला लगा दीजिए। जो निचली 24,000 अदालतें उसमें ताला लगा दीजिए और तालिबान का फॉर्मेट जो
सर आपके पार्टी के हैं मिस्टर यादव, उन्होंने कहा था लोअर कोर्ट्स विल सेट द कंट्री ऑन फायर। वो शायद एक बार सुन लीजिएगा अभी डिबेट के बाद, एक बार वो क्लिप सुन लीजिएगा। We've run out of time. Tushar, I'm sorry, we've run out of time. Gentlemen, thank you for joining us. The news are with Navita Kumar on the other side.